Hello, everyone. My name is Erin Carranza, and welcome to Transformation Through Unification. And this is a very good friend of mine. His name is Attorney Vincent Davis. And we're here today because I had some questions about appeals and about getting judges removed from your case if you think they're biased or anything like that. So I figured I would ask Vince, and then I thought, let me just have my answers broadcasted to everyone. So I am out of dependency court and I am now in family court, which is a whole different monster, by the way. I didn't realize what it's like, a different world completely. I wanted to get the hell out of dependency court, and then it was like, what is it, out of the fire and into the pan?
Was that a question for me?
Yeah.
Oh,
Isn't that the saying? Is out of the, or is it into the pan and out of the fire and
no,
into the
from
pan?
the frying pan to the fire.
Yeah. So why don't you explain a little bit about yourself?
Well, I'm a lawyer in California, 35 plus years. I have a law firm and it's in Los Angeles County, main office in Arcadia, California. And at least 50 to 60% of our practice is devoted to cases in the CPS courts, defending parents and relatives, trying to get children keep back in the family home, keeping families together. And we also sue social workers for civil rights violations. So that's what I do. And, I, Erin and I used to have a show together many eons ago. And now she's keeping her show going. And I'm glad to see that. Glad to see that she's still helping people through the CPS maze. She's gone through it herself, and now she's going through the back end, the family law portion. So these proceedings, both in CPS court and family law court, can be, trying, difficult, exhausting. So if people, need any type of consultation or help, always give me a call. Vincent Davis, just Google me.
I actually, that's how I found you when my daughter was removed. I just Googled top CPS attorneys in California, and then you popped up.
Mhm.
And I always tell everybody that you're the reason that I'm doing this, because I was able to stop spiraling out of control in this process when you told me your kid's removed, get over it. Like, that's it. And, I always say at first I was offended, but then I was like, he's right. And that's what I tell my clients now is, I'm sorry it happened. It really hurts, but get over it.
Right.
You have such
So,
a short amount of time. And before you know it, you're at 6 months, 12 months, 18 months, and then your kid's gone.
right. I try to stress that with a lot of people. A lot of people come to me, at different stages of the
Mhm.
case, and I've divided the cases up into modules, 5 or 6 modules.
Mhm.
Today, a lady called me from module 7. Her
Oh, yeah.
children have been adopted out,
Mhm.
and she wanted to tell me all about module 1
Right.
and module 2. And I listened to her for about 45 minutes, but I just had to tell her. I said, "Ma'am, you're focusing on the wrong thing.
Mhm.
You're in module 7 and you're talking about module 1 and 2." Well, she says, "I just want you to hear the story of how I got screwed."
Mhm.
And I said, "Well, I thought you wanted me to tell you what you could do at this point.
Right.
That has nothing to do with the story." And a lot of people get offended about that,
Mhm.
you
Yeah,
know.
I tell him, I said, "Forget about that for now. Put a pin in it. We will come back around and then you can punish them later, but let's focus on getting your kid back first. The
Right,
removal happened. That's it. It's done. There's no going back."
right. A lot of people don't call me until, a lot of things have happened in the case. A lot of people think, oh, they took my kid. This must be a mistake. I'll go talk to the judge. I'll get the judge back.
Mhm.
I'll get the kids back from the judge.
Mhm.
And then after 1 or 2 hearings, oh, things will be all right. And, then they're calling me, 3 months away from the TPR hearing.
Yeah.
before they get their rights terminated. And it's like, well, what happened? We talked 18 months ago. I thought everything turned out right for you.
Mm-hmm.
No, Mr. Davis, it didn't turn out right. I should have, worked with you earlier.
Mm-hmm.
But a lot of times, it's too late. And a lot of people I have a hard time accepting that their government will screw them.
Oh,
But,
you think if you're a good parent, you have nothing to worry
right,
about.
you
Come
think
on
that, oh,
in.
right,
No.
right. So, I don't know how to tell people or make them believe that that's not accurate. And I say, hey, do you watch the news? Yeah. Do you ever see government corruption on the news? Yeah, every day. I
Mhm.
said, do you think the system that we're involved in is no different?
And, it's mind-boggling. I always say, like Benjamin Franklin said, until those who are unaffected by this problem are affected, we're not going to have any change.
Right, right.
So if your neighbor thinks that the CPS is, saviors, it's going to still say that way.
Hmm.
We have to change legislation. We have to change the way people think and the way they look at DCFS, because they told me, oh, we have no problem leaving your daughter in your care. A couple of days later, they removed her without a warrant. They didn't contact my tribe. They didn't do any of these things that are set up as our rights, or these safeguards to protect us from our overextending government. And not, and then you're just stuck there not knowing what to do, and you're at 3 months, you're at 6 months. They don't
Right.
tell you that your CPS social worker will not set up your counseling for you, and you have X
Hmm.
amount of time to do your services. You have to be on top of that. They don't
Right,
tell you any of that.
right.
I haven't met a single client whose reunification was always, they always say it, but it's never ever been the case. It doesn't seem to me that reunification is the case right now. It's removal first, and then, oh well.
Hmm.
Um,
Hmm.
and I know that my daughter was. I know that my Fourth Amendment was violated. My 14th Amendment was violated. I also know that the social worker conspired with the therapist to commit fraud in my case. So I know that I have a lawsuit, and also there's a time limit, right? So I want you to tell people how long they have to sue. Is it from the start of your case, or is it for when your case is dismissed? And do your children have the right to sue if they've been removed?
Well, let's go in reverse order. Your children has the right to sue.
Hmm.
And generally, their time starts ticking when they're 18.
Hmm.
They can bring a lawsuit beforehand, but
Hmm.
they have 2 years from their 18th birthday to actually file the lawsuit.
Hmm.
When you should sue, it gets a little bit more complicated. Generally, it's 2 years from the violation of the right.
Hmm.
So it could be 2 years from, the time they came out to take your child. It could be 2 years from the time that the social worker wrote a report that contained falsities.
Hmm.
It could be 2 years from the time the social worker got on the stand and testified falsely
Hmm.
against you. So, computing that 2 year date is always the trick. But generally, I can say you have 2 years. Now, the trick is 2 years from what,
Hmm.
right? And I've seen over the years, several cases that I thought were good cases get thrown out of court because of the statute of limitations defense that social workers have. In other words, the parent waited too long to do something.
Hmm.
Someone called me the other day and they wanted to sue on something that happened 8 years ago. 8 years ago. And I thought, to myself, how am I going to tell this lady that
Hmm.
there's nothing she can do? She's waited too long. It's bad enough that social workers enjoy qualified immunity, that
Hmm.
defense, but, there's other defenses that they have, and their lawyers will assert those defenses. And if statute of limitations is one of them, you
Hmm.
know, that's what's going to be, used.
Right. So my daughter was removed 2 years in October. This coming October will be 2 years.
Okay, so the earliest date that your time will lapse will be 2 years on that date in October.
Hmm.
Now, it could be longer, but
Hmm.
I wouldn't wait on that.
No.
If you're going to sue for violation of your Fourth Amendment for detaining your child without a warrant, you
Hmm.
better file before that date.
Right.
Period. End of story.
Now, you mentioned that social workers have qualified immunity. Now,
Hmm.
judges, they have absolute immunity and qualified immunity, correct?
Well, there's several different types of immunity
Hmm.
depending on what you're talking about.
Judicial immunity.
Right. But there's also something called transactional immunity,
Hmm.
qualified immunity, absolute immunity. And so when you want to sue someone, especially a government agent,
Hmm.
they pass the laws to protect government agents.
Right.
I don't know if you remember when they were complaining about the police and they wanted to take away the police's qualified immunity.
Hmm.
Same thing for social workers. They enjoy qualified immunity. Back, I want to say it was the late 80s, I had just started doing this type of work. And, if the social worker looked at you wrong, you could sue her,
Right.
right? And then the state of, I think it was Washington, passed a law that said, we're going to give social workers qualified immunity,
Hmm.
which means it's harder for you to sue that social worker and you have to jump over a lot of hurdles. Well, that case went all the way up to the United States Supreme Court. And in a 5-4 decision, the Supreme Court of the United States said that law was constitutional. There were a lot of arguments why it shouldn't be constitutional,
Hmm.
but it was held to be constitutional. And you know what happened? All of the states in the Union passed that qualified immunity
Hmm.
law because what was happening was social workers getting sued right and left, and the states and the counties were losing so much money
Hmm.
because social workers were just wholesale violating people's rights.
Right.
And they made it harder for you to sue a social worker. So
Even if
you
they are lying, you said that you had a client where they lied on the stand and got promoted, right?
well, yeah, but she was sued. That
Uh-huh.
social worker was sued,
Hmm.
and she they paid off the settlement, so they lost the lawsuit.
Hmm.
But the social worker ended up getting promoted, and it was always my opinion that the promotion came because the social worker protected those above her in the lawsuit.
Right.
She ended up saying in a video deposition, I haven't watched the depo in a long time, and a couple people have asked me to post the deposition online, and I just haven't gotten around to it.
Hmm.
But as I recall, she said that everything that was done wrong, basically, she decided to do herself.
Uh-huh.
And I kind of knew that wasn't accurate. Um, but, the settlement they offered the client was life changing money, and the client wanted to settle.
Right.
So that whole fiasco died out. Um, my client did report the case to the United States Department of Justice for
Hmm.
some type of criminal prosecution because the woman, she had signed some declarations under penalty of perjury that
Right.
she later admitted in a video deposition that she signed knowing that they were incorrect or that they were false. And, if you or I would do that, we'd be under the jailhouse. In this particular case, for whatever reason, the Department of Justice decided not to prosecute, not even pick up the case or investigate it.
Yeah,
So,
you can, I mean, in my case, you can do everything right. You can literally benefit so much from services. You're teaching people how to benefit from services, and it's still not good. You're still getting in trouble.
right.
I lost my visitation with my daughter just 2 weeks ago because the judge didn't like my job. Literally, that's why he said he was taking my visits away, was because he thought my job was odd and weird. Quote.
I really wish you get a copy of that transcript and
I will
show it to
have
me.
them on Monday.
Because if that's accurate, Aaron,
Hmm.
uh, there's a lot you can do, and we'll talk about that.
He
But
also told me
that's
that I wasn't allowed to object.
yeah.
See,
Hmm.
and I asked him, and I said, I object to that. He didn't like that. I caught myself, but but no, yeah, he told me that I wasn't allowed to object. I could disagree, but he didn't. If I object, it goes on the legal record, and he didn't want it on the record. Well,
I
Mario was trying to introduce a hearsay and improper introduction of evidence and blah blah blah.
you, I always thought that for some reason you are getting um,
Railroad.
rulings, rulings against you, and it might have to do with people's perception of you. Like people don't like troublemakers, and if you go into the legal system,
Hmm.
and especially if you're not a lawyer and you try to assert your rights, people look at you like, oh, she's crazy.
Hmm.
When in actuality, that's not accurate. And, it's just a person that's trying to stand up for her rights. But
He
you don't
got
see that. You don't see that in the law so much, or in in courts so much. And, when people see it, they think, oh, crazy, cray, cray.
yeah, he was like, so, do you tell your clients you're in this predicament? And I said, I absolutely do. Absolutely. And I'm not claiming to be an expert in family court. I was like, I've testified in dependency court as an expert witness. So I think that qualifies as me saying that I'm an expert in supervised visitation in dependency court. Um, and then he also told me that I wasn't my daughter's mother because there's a restraining order against me with my husband, or now ex-husband. I said, he needs to communicate with me. We need to co-parent. My ex has 33 missed visits, which totals up to 7 months out of 10 months. And I have a hearing for contempt of court. He dismissed it. He said, oh, no, no, no.
You should consider filing that notice of appeal. You know, I
Mm-hmm.
wasn't at the hearing. I don't know the judge. I haven't seen the moving or opposing papers. But
Mm-hmm.
what you're telling me, it just sounds alarming.
It sounds made up. If I didn't sit there and live it, I'd be like, there's no way a judge in the United States of America is telling you you are not allowed to object in a court of law.
Right.
And he did not take away your child because he didn't like your job. But he absolutely did. He looked at this up and he couldn't find any other reason to side
Did you
with Mario.
did you
So
have a court reporter there?
yes, I get the transcripts tomorrow. I paid extra to have them expedited.
Okay. All right. Hey,
Yeah, 15 pages.
I got a lot of stuff that I have to try to finish um, this evening. I've been under the weather. So you wanted to ask me, no, I'm not leaving right now. You wanted to ask me about appeals.
Right. I wanted to ask you about the appeal process. Can
Go
you
ahead.
one what is it? I know that under 1983 you can file an appeal, or
No, 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 no. 1983 is a civil rights case
that's right.
where
That's right.
you
That's a lawsuit.
sue the county. Um,
This is why I have you come on here.
you sue the county for civil rights violations, or the social
Mm,
worker for civil rights violations. Appeals in CPS cases usually happen, at least in California, in these stages.
mhm,
The first stage of the case is the detention hearing.
mhm,
If you don't like what happens at the detention hearing, you have to file a special type of appeal, a writ. And it's discretionary whether the Court of Appeals is going to do anything about or even hear the case. The next hearing is the jurisdictional and dispositional hearing. After both of those hearings, if you don't like what happens or what the judge orders, you can file a notice of appeal.
mhm.
All right. Then there's the 6 month date, 6 month review date. If you don't like what happens, you can file a notice of appeal. Same at a 12-month date. But if at any 6 month date or even at the disposition, your rights to reunification services are terminated, you have to file a special type of writ that basically is an appeal, but they call it a writ. where you can appeal through a writ your termination of family reunification services, which is a milestone in the case and something you might always want to fight. After that, they would have the 366.26 hearing,
Mm-hmm.
which is the termination of your parental rights, and if your rights are terminated, you have the right to appeal that as well. After that, presumably there would be an adoptions hearing, and you don't have the right to appeal that because you're not even a party to the case anymore.
Mm-hmm.
Now, the appellate process in California for CPS cases is this, and it's probably the same for a lot of states. You're in the trial court, you lose, you appeal to what's called the Court of Appeals. If you lose there, you can also appeal to your state's Supreme Court.
Mm-hmm.
And then, if you're feeling bold and you still lose, you can try to appeal to the United States Supreme Court. So that's basically the appellate process for a CPS case.
Can you have a judge removed from your case, or uh,
Mhm.
ask for another one?
Well, yeah. So here's the way that happens, or usually happens. And all of this is covered in California in the California Code of Civil Procedure.
Mm-hmm.
They call it the CCP, Code of Civil Procedure. And around section 170, 170.1, 2, 3, 4, 5, and 6, there are ways that you can change your judge. The easiest way is to file what's called a affidavit of prejudice, but you have to file that the first time the judge appears on the case. Now, there have been interesting rulings in CPS cases that you don't have to file the 170.6 until the judge makes a finding of fact. So when you go to the detention hearing and your judge hears a case, but then you don't like the judge,
Mm-hmm.
you still can file the 170.6 to get rid of the judge, or to change judges. Now, that's an unusual ruling because the Court of Appeals in California said, oh, the judge heard the detention, but that wasn't really a factual hearing for the judge to determine anything. It was just to determine whether the social worker stated a cause of action against you to detain your children.
Mm-hmm.
So in juvenile court, you have to file the 176 within a certain amount of time, but it can be after the detention hearing.
Now you
If
can't.
you
Oh, sorry. Go ahead.
if you miss that time period, you're out of luck. Then you can get a new judge by filing a motion to have a judge disqualified. And I've actually seen that in my career in juvenile cases. I've seen it work. Um, there was an attorney. I was on the case with an attorney. I represented the father. He represented the mother. And the judge had made a certain kind of ruling against affecting his client,
Mm-hmm.
and the attorney filed a motion to have the judge changed, and it was granted. But there's some tricks with that. If you file a motion to disqualify a judge, what happens is that the case, according to the law in California, the statutes, the judge is supposed to be who hears that is not the judge on your case,
Mm-hmm.
and even not the judge in the county.
Mm-hmm.
But another judge in another county is supposed to hear the case and decide the case.
Mm-hmm.
Well, what happens a lot of times in CPS court, and over the years I've seen this, the judge who tries to make the decision is the judge who you filed against, which is a no-no,
Mm-hmm.
or a judge in that building,
Right.
which is a no-no,
Mm-hmm.
or a judge, downtown LA,
Mm-hmm.
if the case is in LA County. And that's a no-no. The statute, and I haven't looked at the statute in a long time, but the statute actually says that it's supposed to be a judge out of county. Now, what happens is if you and your attorney don't object to the wrong judge hearing the case, you're screwed. You're waived. You waive that,
Mm-hmm.
So you and your
And that's at the
attorney,
beginning, right?
oh yeah, that a very big thing.
Mm-hmm. What about, you're not going to like the judge. Let's just get that out of the way. He's not there to be your friend. He's not there to, you know, pat you on the back when you're upset. What are the legal reasons for requesting a different judge, like
Well,
bias and things?
well, if you don't do it on that first shot,
Right.
you know, you can just say, "Oh, I think the judge will be prejudiced," and you'll get a new judge.
Uh-huh.
But if you miss that first shot, that automatic, and you only have one, you can
Mm-hmm.
only do that one time. So what happens to some people is, frying pan to the fire. They went from a judge that they don't like to a judge that even they don't like more,
Yeah.
and then you're really, kind of
Mm-hmm.
screwed. But if you're making a motion, it's called, actual prejudice.
Mm-hmm.
So, I mean, I've never seen this happen, but it's just an example I give people. Let's say you're African American and the judge makes a comment, "I don't like African Americans."
Mm-hmm.
That's actual prejudice. Or what if you're blonde haired and blue eyed and the judge says, "Hey, I don't like blondes"?
I don't think my judge liked my bow tie.
Oh,
I can't wrap my brain around what happened. I was like, wait a minute.
right.
But
So
um
there, but now here, this is important, Aaron.
yes.
You can't get a new judge based upon the fact that the judge made a ruling against you,
Mm-hmm.
or even the wrong ruling against you.
Mm-hmm.
What you have to do is you have to file a writ or an appeal and get the judge overturned.
Mm-hmm.
If you get the judge reversed, you then are entitled to that new automatic, you know, affidavit of prejudice, and you get a new judge.
Well, see, and that's what people don't get. People don't understand that that's the process. They think, okay, automatically this judge is a jerk and he's racist, so I'm gonna just remove him. It doesn't work like that.
No, and you have to have actual evidence,
Right.
that the guys or the gals are racist, and
Mm-hmm.
and generally nowadays people aren't going to say that, right? They're not going to, this isn't 1940 where some judge may just spout off from the bench.
Mm-hmm.
Most judges, they won't say anything like that because they
Mm-hmm.
know it's wrong. So why, shoot themselves in the foot? It's something that you have to, um, kind of prove. Another way to do it is, a lot of I've seen this happen, not a lot of times, but they say the judge has a conflict of interest. For
Mm-hmm.
example, uh, you're the father, and I'm the father, and you're the mother, and the judge, and we're against each other, and the judge is your uncle.
Mm-hmm.
Well, that would be a basis for filing a conflict of interest. He has a familial interest. There is a judge in LA County that does CPS cases who I used to be married to. And subsequently, we were divorced, we were law partners, and then she she had a judicial career, and then she came back to work for me for 6 or 7 years.
Mm-hmm.
And then she went back on the bench. They asked her to go back on the bench in juvenile dependency cases here in LA County. And whenever our case comes up, or a case with my firm,
Mm-hmm.
she just automatically disqualifies herself, and she gets, which she should do, but if she didn't, I could, or we could make a motion to try to disqualify her because, there might be a conflict of interest.
Right. And you can complain about judges, correct? There's like a
Oh, yeah.
board that
Yeah.
you can
There,
go.
there's something called in California, and I'm sure they have this in all states. In California, it's called the California Judicial Commission. And, it used to be judges reviewing judges, which sometimes, the theory was that the sometimes the judges would give the judge who was being complained against, the benefit of the doubt when he or she shouldn't have the benefit of the doubt. So now the commission is made up of non-attorneys, non-judges,
Mm-hmm.
who, um, put their 2 cents in when voting, to see if a judge did something improperly.
Mm-hmm.
So I haven't, it's not something that I keep up on, but over the years, I've noticed there are a lot of judges, not a lot, but judges have been slapped on the wrist and disciplined or even, forced off the bench because of some conduct that they may have participated in.
Now, when you decide to sue. You can sue everybody, correct? Like in your case, the judge, the clerk, the lawyers, county council. You
Well,
can't just.
that's an interesting question. I guess, it's California, you can sue anybody for anything, but should you sue everybody? And it's a
Mhm,
bad, that's a bad strategy to sue everyone.
mhm,
In your case, you should probably sue the social worker in the county of, where your case was.
mhm,
But it's bad strategy to sue a judge.
mhm,
Um, clerk has nothing to do with it, right?
mhm,
The bailiff has nothing to do with the case,
mhm,
presumably.
mhm.
Although I've heard stories about, bailiffs giving input, perhaps when they should not be.
Oh
But
yeah.
generally, you just want to focus on your civil rights being violated by the social workers and or the county where your case was.
Like therapists,
Well,
you can include
that's a
them.
whole that's a whole nother thing. If you have a therapist that committed malpractice, I'd forgotten about that with your case. I'd
Hmm.
forgotten all about that. But
Yeah.
that in my mind, that would be a separate case
Hmm.
that you would have against that particular therapist for perhaps malpractice or some type of fraud or something.
Hmm. A
It might be,
retaliation.
yeah, it might be hard for you to sue them under civil rights because a civil rights defendant has to be what's called a government actor,
Hmm.
right? Hold on a second.
Well, yeah, she was conspiring with my caseworker to. I would get close to finishing my therapy sessions, and then all of a sudden, I needed more sessions.
Hold on a second. Hold on.
Hmm.
I have to type something.
It's okay. I'm just gonna tell them what happened while you type. So I was finishing my therapy, and at my last session, we had nothing to talk about because I had done the work that I was supposed to do. I was teaching her how to put eyelashes on at our last session.
Hmm.
The report got to my social worker, and it was horrible. It was so bad. Um, my public defender went crazy, and she called the therapist, and the therapist said, "You have to make an appointment and pay $150 to see me to get clarification on my report." So my public defender said, "Oh hell no." So she had to go to the top of this. She had to find the director of this therapy place, and because the therapist said that I was aggressive, that I was upset with her. Well, yeah, I was, because your report specifically kept me from getting my child back. So DCFS gave me a second time to do a therapy, and they didn't think I was going to finish my services. I finished them the day before because I got a therapist who was very anti DCFS and the damage that they do.
Hmm.
So we would do 2 sessions a day just to get. So I would went to my hearing with all my services done. Now DCFS said I didn't finish my services because they wouldn't accept the handwritten piece of paper from my therapist because we didn't have time to print it out. So they said technically I didn't finish my services. They didn't get my certificate because improper.
Hmm.
I don't know, but I know that when you sign on the bottom of the line for services in the fine black print, in the little tiny print, it says you are still responsible for the remainder of your sessions whether or not DCFS is involved. So DCFS can pull out and you're still responsible for 10 more sessions. And so I stumbled across a little scam where the county would pay for the original 10 sessions. They would suggest 5 more sessions or 3 more sessions, and then the county would pull out, and you're on the hook for these sessions at $150. Money going straight to the therapist.
Hmm.
So you're saying in that case, that would be a separate lawsuit, not in whole.
Well, you could bring it in the same lawsuit, but I would probably bring it differently,
Mm-hmm.
separately.
Mm-hmm. So there's no like collusion or anything like that.
Yeah. The more defendants, this is just my opinion. The more defendants you have in a case,
Mm-hmm.
the harder that case becomes for you to
Right.
win. Because
Messy.
all the defendants are working together against you.
Mm-hmm.
So sometimes you might want to try, if you can, might want to try to keep them apart. Now, some defendants, when sued separately in different lawsuits, will make a motion to consolidate the case.
Mm-hmm.
Then you have to deal with that as well. But if I were you, I think I would start off with, suing the social worker and the
Right. Especially since
county.
I have like 2 months left before my
Hmm.
2 years is up. So you um file a notice of appeal and file a judicial complaint, but there was something else on that. When you file the appeal, you must also file notice of designation of court records, right?
Well, yeah, there's two things that starts an appeal: the notice of appeal. But see, here's the thing: if you're appealing a juvenile case, you don't have to file the notice of designation of the court record.
Mm-hmm.
There's a special rule where the juvenile court has to put in all the proper records. And what happens, and this happened to me in a couple of appeals over my career, they didn't include everything that I wanted. So, you had to make a motion to augment. But in your case, your family law case, you have to file the notice of appeal, and within so many days, and the better practice is to do it the same day. In a family law case, you got to file that notice of designation of the court record,
Mm-hmm.
and that's the court reporters' transcripts. You got to give the days and dates, and then there's the clerk's what do they call it? The clerk's record, which
Right.
is the minute orders and all the motions and stuff that had been filed. Because
You know,
you want to make sure that the
go
court of
ahead.
appeal you want to make sure that the court of appeals has all of the right information when they decide when they decide your case.
What I found interesting is that the clerk is an independent little person from the court itself. I had to pay for the transcripts this lady personally. I thought
Well,
I would.
well, that
I
was the court reporter. That
right,
wasn't the court clerk.
right.
The court
That's what I meant. This
reporters
is the
are
reporter.
independent. Yeah, they are independent in terms of you have to pay them to do the transcript, because I think the court only pays them to be there
Uh huh.
and to take to type out the records. If you want a copy of it, it's not court ordered or something, you have to pay for it.
Hmm. Now, is there always a court recorder in the courtroom, or do you have to request it?
In family law, I think you have to request it.
I
In the
got
old
lucky.
days,
Got lucky.
when I used to do a lot of family law, there was always a court reporter. You have to,
Mhm.
but I think you have to request it. In juvenile court, though, in CPS court, there's always a court reporter.
Mhm.
I think that's just in the statutes.
I got lucky because she happened to be there last 2 weeks ago. But um, so I like to tell everyone, like you say, is that just because you think that it should be this way, or because this is reasonable, or that's not law. That's not what the law is. It's something completely different.
Hmm. Definitely.
It's not what you think it should be. It's pretty much usually the opposite of what you think it should be. Like, I didn't know that dismiss with prejudice is a good thing, but
Well,
dismiss without prejudice
it
is
depends on what side you're on.
right. So in my case, they dismissed allegations of drug abuse with prejudice. And I was like, oh, what? Because I thought that was something bad. No, that just means that they can't revisit the same thing, right?
Correct. Correct.
Mhm.
Unless they come up with new allegations.
Right.
So in your case, they said, during days 1 to 100, you were a drug addict,
Hmm.
and then they dismiss it on day 101. They
Hmm.
can bring new allegations that happen in day 120
Hmm.
of alleged drug abuse, but
Hmm.
they can't go back to days 1 through 100.
Yeah. So always make sure that you have a lawyer. And if you don't have a lawyer, you really have to. There's so many little. What I'm finding is there's so many little nuts and bolts, and I can go on Google all day long and be a Google lawyer, but that doesn't mean I can go in the, go in the kitchen and make it happen. Like procedure, and I got in trouble for filing too many things the other day. Well, I was just responding and then to stuff, and I asked for him to throw this out and throw that out, and he got mad at me and he said it was too much work for the court, and I said you took away my kid. I'm gonna file, and he told me that, and I was like, I'm gonna file something else, because I wasn't disrespectful, and I got to the point where I knew it didn't matter what I said or what I did. This is what it was going to be, and so I shut my mouth.
Mm-hmm.
There's nothing more powerful than silence, let me tell you, coming from a person that told their social worker to F off.
I just saw the note that you just.
Mm-hmm.
So, okay. Well,
So we're gonna I have a little bit of an emergency, so we're gonna scoot. But thank you for coming on, Vince. It's really good to see you and to talk about some of these things, these little details.
okay. Well,
And
people
I
want
was
to
just
get
gonna
in
say,
touch.
give you get in touch
Yeah,
with
my
you.
telephone number is 888-888-6582, and my website is Vince. Or for this show, will be fightchildprotectiveservices.com.
And I'm Erin Carranza, and I can also get you in touch with Vince if you need it. You can email me here or at transformationthroughunification.com. And I will see you guys next week. Thank you,
All right.
Vince.
Good night. Bye bye.
Good night.